I, ooh, all right. I'll say that again. I'm here to talk about the Equal Rights Amendment. Um, I got involved in the Equal Rights Amendment about 5 years ago. I was in a room. We were with all the faculty at the law school were having their pictures taken, the big faculty, joint picture. And John Mills, who's the director of the Center for Governmental Responsibility, leaned over to me and said, "Dania, you're a woman. Do you want to work on the ERA?" And I said, "What? Isn't that dead?" And he said, "No, no, 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 no. I've got a project for you." And I thought, well, let me go find out about the project. Now I'm the director of the Center for Governmental Responsibility. So it gets you sucked in. Um, okay, so let me make sure this thing works. Nope, doesn't work. Click the little button on there. So I have a slideshow. I'm going to try to go as quickly as possible without being too fast. Nope, nope. Or should I turn it that way? Just turn it that way. And the problem is I ate one of those tuxedo bombs in the restaurant just now. And that thing must have 8,000 calories in it. So I'm going to talk about 100 miles an hour. Okay. So I'm going to talk a little bit about constitutional amendments generally. Wait a minute. Now I'm too far ahead. Go back. Go back. Why is this not moving? There we go. So we have had 28 amendments to the Constitution since it was ratified in whenever it was 1787. We have, and the constitutional amendments, can we move that little off of the slide? No, don't stop sharing. Just move the little picture up to the far corner. Just grab it. Yeah, there we go. Okay, so constitutional amendments have come in phases. We really had 4 phases. The first phase came in the first basically 10 years, 15 years after the Constitution was ratified. There were 12 amendments to the Constitution, of course, the first 10 being the Bill of Rights. And then we didn't have another constitutional amendment for well over 50 years. And then we had the 3 Civil War amendments. And then we had another chunk of time, 40 years. And then we had the New Deal progressive era amendments, where that's when we got the women's suffrage amendment. And then we had a little gap. It's not as huge a gap, 15 years or so. And we get the 4th set of amendments, which are really the civil rights amendments. They're not all civil rights amendments, but a number of them are on things like the abolishing the poll tax and giving 18-year-olds the right to vote. But so these 4 periods represented periods in this country of times when the politics demanded change, demanded that the Constitution adapt to what it had, to change to meet new times. And these 4 periods are very important periods. So the Equal Rights Amendment, if you look on the bottom, only 6 amendment proposals have ever not been ratified. The bottom one, the number of constituents per representative, that one's obsolete. The ban on aristocratic titles, we may need that one back. I'm not sure under the circumstances with King Trump. The ban on anti-slavery laws, that was actually an amendment called the Corwin Amendment that attempted had it passed, it would have said we could have never abolished slavery. So hopefully that one is not going to arrive. That one's gone. The child labor amendment, that one's a little troubling because although we now have legislation to prohibit child labor, there was talk recently of modifying that and allowing younger children to actually work in factories. It was primarily immigrant children that we wanted to go ahead and allow to be work in child labor. So the last 2, though, the Equal Rights Amendment and the congressional representative, we call that the DC Statehood Amendment. Those are the only 2 that really have any viability left. The DC Statehood Amendment, I think, has only received 38 ratifications, but the ERA has received 38, which is the requisite 3/4 required under Article 5. Should I stand back there and do that? Oh, you know what? No, it's on. Oh, wait, that did it. Right on this page, is that right? Yeah, okay, don't touch. Okay, so Article 5 of the Constitution, this is the provision that allows for amendment to the Constitution. It has three provisions. The first part in purple allows the Congress or the states, with 2/3 of them, to propose constitutional amendments. So it means both Congress or I should say either Congress or the states could propose. So it's a shared power. Then it says, once they're proposed, they will be valid to all intents and purposes when ratified by the legislatures of 3/4 of the states, or by conventions in 3/4 thereof. So the states have the sole ratifying function. Nobody else has any role in the ratifying. So that's in blue. And then as the one or the other mode of ratification may be proposed by the Congress. So Congress has the sole power to decide the mode of ratification. The states ratify either by legislation or convention, and then either the states or Congress, which is why it's in purple because it's blue and red, can propose. So that's the process for constitutional amendment. Ha, look at that. But there are some pretty big gaping holes in Article 5, if you think about that, right? So I know, sorry that the print is so small. Do both houses of Congress have to actually pass the proposal in the same year, the same session, the same decade, or the same century? It doesn't say anything as to when the two houses of Congress have to actually pass the proposal. Do the states have to follow a particular procedure in terms of ratification? Do we need a supermajority of legislators, a supermajority of those present, a majority of all legislators, a majority of those present? Do we need the governor's signature? Do we need a public referendum? Can they be constitutionally required to ratify or precluded from ratifying? One of the things we were thinking about with the ERA is, could the populace, the Florida public, pass a constitutional amendment to our Florida Constitution requiring our Florida legislature to ratify the ERA? Interesting question. Never been addressed, though there have been some attempts through public referendum, through legislation, to force recalcitrant legislators to ratify amendments. But of course, Article 5 says nothing of that, right? Can a state constitutional amendment limit the legislative process of ratification? In other words, could we as the people of the state of Florida pass a constitutional amendment that says we have to have 9/10 of the legislature is necessary to ratify a constitutional amendment? All of that is silent. And those are all issues that have arisen in prior amendments to the Constitution. None of these are completely far-fetched. And then a third big question is whether Congress can impose ratification requirements or prohibit requirements as part of determining the mode of ratification. So remember, the mode of ratification is solely within Congress's power. Does Congress have the authority to impose additional requirements? 7 years. You have to do it with a supermajority. You have to do it with a convention and a legislation, right? Or there has to be a supervening election or something like that. Is that within Congress's mode of ratification power? So these are huge questions that many of them have come up and been sidestepped. Very few of these have actually been litigated, or do we have any resolution on them? So in 1923, so this is during the Progressive Era, during that third period of constitutional amendments, the Lucretia Mott Amendment was first introduced into Congress, which said men and women shall have equal rights throughout the United States, and Congress shall have the power to enforce this article by appropriate legislation. That did not come out of Congress. It took 49 years before a technical, used a technical device to get the ERA actually out of both, to the floor of both houses. So we would have the House would vote for a while, and the Senate would not allow it out. And then the Senate would allow it out, and then the House would not. So it took 49 years to get the Equal Rights Amendment out and to the states. So it has, we start with the we call it the resolving clause. So that's the preamble. It says resolved by the Senate and the House of Representatives, 2/3 of each house concurring, that the following article is proposed as an amendment to the Constitution, which shall be valid to all intents and purposes, when ratified by the legislatures of 3/4 of the several states within 7 years from the date of its submission by the Congress. So the first question is, how do we get those within 7 years? Where does the authority of Congress come from to impose that 7-year deadline? It's in the resolution, it's in the preamble. The actual text of the Constitution says equality of rights under the law shall not be denied or abridged on account of sex. Congress has the power to enforce. And then we have Section 3, which says this amendment shall take effect 2 years after the date of ratification. So both the 2-year timeline, or the 2-year sort of delay, and then the 7-year requirement for ratification are two issues that are gonna, I don't know, they're gonna follow this amendment, the Equal Rights Amendment, and they'll come back up. So the ratification process, it came out on March 22nd, it came out in March 22nd, 1972 is when it was issued to the states. Within the first year, 30 states had ratified. In year 2, 3 more states ratified. In year 3, 1 state ratified. Year 4, no states ratified. Year 5, 1 more state ratified. And we had 35 out of the necessary 38 states for ratification. Florida was on the cusp of whether it was actually going to ratify or not, and it chose not to ratify. So on March 22nd, 79, that original 7-year deadline expired, and Congress extended it by 3 years and 3 months, 3 years and 3 months. And this was very controversial because the 35 states that had already ratified the ERA had presumably ratified it based on this 7-year deadline. How dare Congress give more time? And what authority do they have after the amendment has gone to the states to change? But the general consensus was, and they did not get 2/3 vote to extend the deadline. They only had a majority vote to extend the deadline. The general consensus was because it was in the preamble. It was not actually in the text of the Constitution, a constitutional amendment that's being ratified, we could change the deadline. So nothing happened for however many 40 more years. Year 45, Nevada ratified in 2017. In 2018, Illinois ratified, and in 2020, Virginia became the 38th state and ratified the ERA. 48 years after it had issued from Congress, clearly in violation of the 7-year deadline. And the question is, does Congress have the authority under Article 5 to impose that 7-year deadline? Really good question, because we don't know. Okay, in addition, 5 states rescinded or sunsetted their ratifications. So Nebraska, Tennessee, and Idaho voted to rescind their ratifications during that period when we were discussing extending the 7-year deadline. So we don't like this. We were wrong. I don't know why we ratified this amendment. We're just going to rescind our ratifications. Uh-oh. Uh-oh. There we go. Oh, okay. Awesome. Kentucky voted to rescind, but they only had a simple majority when they voted to rescind. You actually maybe put that down there. And their state legislation requires a supermajority to ratify. Interesting question. Can you rescind with less than the supermajority that's necessary to ratify? South Dakota passed a joint resolution after the fact to sunset its ratification on the date that the original deadline expired. So after the deadline, or just as the deadline was approaching, they said, oh, oops, we didn't mean a full ratification. We just meant ratification as long as everybody else ratified within the 7-year period. And then North Dakota in 2021 adopted a concurrent resolution to retroactively clarify that it's, oh, by the way, in case anybody didn't know, our 1975 ratification was really only valid through 1979 during the 7-year period. So they did this, you know, what, 30, 40 years later? They said, oh, we didn't mean an actual ratification. We just really meant a contingent ratification. So there's two major issues with regard to the ERA, two glaring legal issues right now. The first is on the deadline. Can Congress impose that deadline under its Article 5 powers? And is that power part of the proposing power, or is it part of the mode of ratification power? Because Congress has two functions under Article 5, is the power to impose the deadline under either one or the other. The other major issue has to do with these rescissions. Can states rescind their ratifications, sunset or retroactively redefine their ratifications after they've already ratified? Is it a one-way process? Because clearly they can deny it. They can vote an amendment proposal down, and then in a later legislative session ratify it. That's clearly been recognized as permissible. Can they go the other way, or is it a one-way street? So what do we know about the deadlines? Well, first off, there were no deadlines imposed in the first 17 amendments. And the first deadline was added to the 18th Amendment by then Senator Warren Harding, because he was trying to kill prohibition. He thought there's no way we'll get all the 30, actually at that point, I think it was like 35 states to ratify within 7 years. So I can look like I'm voting for prohibition, but it'll never happen. Unfortunately, it passed very quickly. So it was ineffective as a political device to kill an amendment, which is what he was clearly hoping to do. As a result of its ineffectiveness, the 19th and the Child Labor Amendment had no deadline. Congress was like, oh, this clearly is not an effective mechanism. We're not going to impose a deadline. The 20th, the 21st, and the 22nd Amendments had deadlines, but they were in the text. They were Section 3 of the amendment itself. So where the ERA has that provision that says, 2 years from now, it comes into effect in 2 years, the 18th, 20th, 21st, and 22nd Amendments, the deadline is actually part of the text that is approved. And there's an argument that is a more, that because the states actually vote and to ratify the text of the amendment, that if they vote to ratify that it's only 7 years, they're okay with the fact that they've only been given 7 years by Congress. But if it's in the preamble, it's a different legal issue. So the 23rd, 24th, 25th, and 26th Amendments all contain deadlines in the preamble, as did the ERA. The 27th Amendment contained no deadline, but that was the one that was part of the original 12 in the Bill of Rights. 2 of the original 12 that were proposed were not ratified. And in 1992, more than 200 years after the Bill of Rights was ratified, the 27th Amendment, which is the Congressional Pay Amendment, was actually ratified. And everybody treats it as a joke, because what did we need this amendment from way back in 1791? But it got ratified. And of course, the longer you wait, the more states you need to ratify it. And a history student at the University of Texas started looking it up, found where a number of states had ratified it, and decided, felt that Congress was being a little bit fast and loose, because what the Congressional Pay Amendment says is that it prohibits Congress from passing a bill to give itself a raise. It can give a raise, but it has to be to the next Congress. And they had been spending so much time giving themselves raises that all the states were really happy to pass this bill that said you can't give yourself a raise. You can give a raise for the next Congress, but you can't do this one. And sure enough, it passed overwhelmingly after 200 years. So the question is really, do the states have the authority to decide when it's time for one of these amendments? And can Congress limit it? So the DC representation proposal, which was actually issued right about the time that the ERA deadline was being extended, they decided to be really careful, and they put the deadline both in the preamble and in the text, because just to make sure that we're all clear that this thing has to be ratified within 7 years. So the legal arguments with regard to the deadlines, there's a number of them. There's a federalism issue, right? This is against deadlines, that there was congressional overreach into the states' rights under Article 5 and the 10th Amendment, right? So the whole idea of the Constitution is the states give power to the federal government, and if there is no express power, we assume it remains with the states. So the idea that Congress has the authority to impose a 7-year deadline when it's not expressly granted to them in the Constitution, that's a federalism argument that says, no, that's a power reserved. The states get to decide when they're going to ratify this thing. Another argument is that the preamble is not part of the text. So Congress can change the preamble. And in fact, a bill has been put into Congress, introduced every year since, so really did a lot of good, since 2020, to extend the deadline or to remove the deadline. But Congress has yet to pass any of those bills to remove the deadline from the ERA. I think there's a pretty good argument that 7 years is a really short time for the states to act on a constitutional amendment, given that it took 49 years for Congress to get the amendment out of Congress. And in fact, when it finally was ratified, it only took 48 years. So it was faster at the state level than at the congressional level. Another argument on the deadlines is, does it even, whether Congress even has the power or not, is that a justiciable question? Meaning, is that a question that the courts can even address, or is that a question that ought to be left to Congress? Because the courts have said that, they have this sort of modesty argument where they say, well, that's political. We're not going to get into that issue, so we're going to let Congress decide. And so there's some dicta in some cases that suggest that deadlines might be a non-justiciable issue that should be left with Congress. Arguments in support of the deadlines are that there is a Supreme Court case that upheld it, but minor detail. The Supreme Court case that upheld it is a Supreme Court decision on the 18th Amendment, which was the first one. And of course, the 18th Amendment was fully ratified within the 7 years. And a bootlegger brought a bill, got arrested under the Prohibition Act, and said the National Prohibition Act, argued, is unconstitutional because there was this deadline. And the deadline made the whole thing unconstitutional. And the Supreme Court said, oh, give me a break, right? That it was fully ratified in 3 years. The deadline had no impact. Therefore, the 18th Amendment is valid. They never said Congress has the authority to impose a deadline. They said this deadline in the 18th Amendment did not void the amendment because it was ratified. It met the technical prohibition, met the technical requirements of Article 5, which is 2/3 Congress, 3/4 of the states. End of story. So Dillon is a case that is often trotted out, is the only case on the question of a deadline, and it's really not relevant. And it's about a deadline that was in the text, not a deadline in the preamble. So there's a lot of reasons why Dillon is not a good case, but it often gets trotted out. Another argument in support of deadlines is that it's within that proposal or mode of ratification power, that it's sort of a sub-power. So if you can propose an amendment, you could say, can't discriminate on the basis of sex. Why can't you say can't discriminate on the basis of sex, so long as you all agree to this within 7 years? That it's sort of a subset. If you could propose the whole thing, then why can't you propose a more limited proposal? That's another argument, I think, logically, that doesn't really make a lot of sense. And then also those in support of the deadline say, oh, the deadline is a non-justiciable political question. So we should leave it to Congress and the courts should not intervene. So this is where we're at on the deadlines. Whether a deadline, we don't know. We just don't know. On the rescissions, because that's another question. If 5 states have adequately rescinded, then we're back to 33 states have ratified. We don't have 38 states, even though 38 have ratified. 35 or 5 have technically rescinded. So arguments against the rescission, idea of a rescission, is that, well, no state in the past has been permitted to do it, and a number of states tried. A number of states tried to rescind the 14th Amendment, the 15th Amendment, and the 19th Amendment. Gee, imagine that. Those amendments that dealt with slavery, voting rights, and equal rights, all were states tried to take back their ratifications. And in every one of those, Congress ignored them. They said, you can't do it. But we never had a Supreme Court decision that said you can't do it. I would argue that rescissions destabilize the ratification process. So if I'm the state of Florida and I'm about to put an amendment over the line and Texas decides to rescind, I'm like, why am I spending political capital on a constitutional amendment if another state can pull the rug out from under me? So that argument, I think, is a pretty powerful argument, and we've heard it in various forms. Article 5 only speaks about ratification. There is no, the word rescission does not appear in Article 5. But in favor of rescissions, there's some arguments that if ratification is a power granted to the states, solely to the states, they should also have the power to rescind. I suppose. We could argue that rescinding was never a power ceded to the federal government at all when the Constitution was ratified. Like we gave to the federal government the power to give us amendments and give us back the power to ratify, but we never gave up the power to rescind. And so we still have it. That argument is being made. These are all arguments that are in all of the litigation. And again, whether states may rescind is a non-justiciable political question again. So that's always the answer by some who say, leave it to the political process. This is not a legal issue. Okay, lost my, oh, there we go. So what's the paradox of Article 5, right? The Constitution is really, really unclear. I'll just leave it at that. So is it self-executing? So that's one question. What happens when the 38th state ratifies? Does it immediately go into effect? Does somebody have to say, oh, gosh, yes, state of Virginia, you were the last state. Let me check and make sure you really did have all the right signatures, or you had the right majority or supermajority or whatever your state legislature required. Should somebody check that, or does it just automatically, immediately on the 38th state ratification, become a new constitutional amendment? That, the court has said, happens. As soon as the last state ratifies, it is now part of the Constitution. Nothing else has to happen for it to become an effective part of the Constitution. But of course, somebody has to tell us, were those state ratifications valid? Because the argument here is, were those 3 late states valid ratifications? If they're valid ratifications, then the ERA is validly executed. If they're not valid, then it's not. To what extent can the states establish their own rules? None of that, very little of that has been litigated. If a state, what happens if a state voted to ratify in violation of its own rules? So let's say its rules said you need a supermajority. They only got a simple majority, but the Secretary of State was in favor of it and forwarded that certificate to the National Archivist. And we've got case law that says the state certificate is proof positive. So is there any way to challenge, and do we do that in federal court or do we do that in state court? Do we challenge whether the state actually followed its own rules? And is that certificate of ratification binding or subject to challenge? Not been addressed. Uh-oh. I'm almost done. Oh, there we go. Oop. Okay, I'll just leave those. So the next one is, what's the role of the National Archivist? So the National Archivist is given the task of promulgating constitutional amendments. They are charged with publish it in the Federal Register, tell the whole world that it's now part of the Constitution. But is it just publishing, or does it actually have some significance? Does the National Archivist have a function in validating, determining whether those state ratifications are valid, whether the late ones are valid, whether the rescissions are valid? Does the archivist have any role in that? And then lastly, can Congress require a particular state procedure? So Congress has tried, never successfully, it's never got, Congress has, there have been a number of legislative proposals that have never passed to impose all sorts of requirements on the states. Things like you have to have a supervening election between the proposal and when you actually ratify, or you need a supermajority, or you can only have 7 years, or a number of things. And then could Congress reject a state certificate of ratification? So in this complete limbo, we have virtually no judicial precedent to tell us what to do about this constitutional amendment. We do know the president has no role. And that's important because it is not just the president, but it's the executive branch has no role in constitutional amendments. Congress and the states, that's it. We do know that an ineffective deadline does not void an otherwise validly ratified amendment. So it was ineffective because it never kicked in. It was fully ratified before the 7 years ran. We do know that a state may not impose additional burdens on ratification. So the state cannot impose popular referendum or an intervening election. We don't know whether Congress could make the states do these things. And we do know that a state's ratification certificate is conclusive that the state ratified, I guess. But who knows? Like, that hasn't actually fully been challenged. But there were attempts, because there was a lot of litigation over the 19th Amendment, women's suffrage, where states, especially states that had not ratified, complained about the states that did ratify and tried to argue that their ratifications aren't good. They're not allowed to do that, which clearly didn't go anywhere. Okay, so what happens? So what specifically has happened with the ERA? On January 6th of 2020, the Office of Legal Counsel, which is part of the Department of Justice, is the legal counsel for the executive branch. So this is Department of Justice. It's under the president's office. Issued a memorandum opinion where they said the deadline is valid. Congress has, in our opinion, the deadline. Now, this is not a judicial opinion. This is just a bunch of lawyers in the Trump Department of Justice issued a memorandum that said, we believe the deadline is valid. We don't have to go to the rescissions, because if the deadline is valid, we never got to full constitutional amendment. And that Congress may not revive, and they went so far as to say Congress may not revive this proposal, meaning Congress cannot change that deadline. Congress cannot revive a proposed amendment after a deadline for its ratification has expired. So this was just an opinion out of the Office of Legal Counsel in anticipation of Virginia's ratification. So as soon as Virginia ratified, the next day, they filed a lawsuit against the National Archivist saying, you got to publish. You need to publish this thing. So Virginia, Illinois, and Nevada, the three last states, sued for mandamus to require the National Archivist to promulgate the 28th Amendment, and they filed that in the District Court for the District of Columbia. Oops, lost my. Five states, not surprisingly, the 5 states that had attempted to rescind all moved to intervene in the district court decision, and the court permitted it. So they intervened to say, even if these 3 late state ratifications are good, our 5 state ratifications have been rescinded. So we're nowhere near 38 states. March 5th, 2021, the judge dismissed the lawsuit against the National Archivist, claiming on the grounds that the states did not have standing because the archivist's role is not relevant to the validity of the ERA, right? The deadline, and so basically, whether the archivist publishes or not is irrelevant because amendments are self-executing. They happen immediately. And so whether the archivist publishes or the archivist doesn't publish, that's not going to make the ERA valid. So there's nothing for us to give you. There's no remedy that we can give you because what the archivist does is a purely ministerial act. It's just publication, means nothing, no point. Also went on to say, oh, and by the way, we think the deadline's valid. On appeal, some pro-ERA groups filed in January 2022. At this point, the Virginia governor had changed party. So Virginia pulled out. Now they're a Republican, actually a Republican governor and a Republican AG. So they pulled out of the lawsuit altogether. But the pro-ERA groups appealed it. And the Court of Appeals for the DC Circuit affirmed the decision that the parties lacked standing. So they said, you know, the parties had asked for what's called a writ of mandamus, which is a writ to order the archivist to publish. That's what you get when you want to order a government agent to do something. And the rule is you only get that if it's clear and indisputable, that you have a clear and indisputable right to that remedy. And the court said, well, this is unclear. We don't know if the ERA is valid or not. Because it's unclear, you don't meet the high standard for mandamus. Oh, and by the way, we're not going to talk about the deadline. We're not going to talk about whether the deadline is valid or not. The court acknowledged that whether the deadline was valid would be a matter for a court to decide in a proper case, but this is not the proper case. This one's not the proper case. Okay, lost it again. I think, okay, there we go. So proper cases, do we have a proper case? So we've had a number of lawsuits since. The top one, this court finds the 28th Amendment's lack of publication convincing evidence it does not now exist. This came out of the District Court for the Northern District of California in a case brought by a young man objecting to the draft or registration for the draft. Second one, Taylor's claim under the Equal Rights Amendment fails because there is no such amendment to the United States Constitution. So they don't even get to the legal merits, right, of whether the deadline, and we don't even know if there's an ERA unless we can get to the merits of the deadline and rescissions issue. The Equal Rights Amendment was not ratified and is not part of the US Constitution. Really? Oh, that's good to know. Okay. The federal constitutional questions that the plaintiff's complaint raises concerning the legal status of the ERA are significant. But we're not going to do anything about it. We're not actually going to decide them. The United States Constitution provides a pathway for adding new amendments, and Congress has determined that the last step on that path is certification and publication by the National Archivist. Whether the National Archivist should have done so or should yet do so is not properly before this court. We've had over 9 cases in federal district courts attempting to get to the merits of the deadline, and they've all been sidestepped, either on standing, you know, this technical grounds that, well, the archivist, it's moot, or, well, they haven't published, so clearly it's not an amendment. So I had a friend who said, we've got exactly 43 days before President Trump comes in, so let's get the ERA recognized. So I wrote a letter to President Biden, and I said, well, actually what I really did was I rewrote that 2020 OLC memorandum. And I said, and it was a very nice memorandum that I wrote, I personally think. I said, you know, when we issued that amendment, that memorandum in 2020, we knew the issue of the deadlines and the rescissions were going to have to go to the courts and be decided in a case on the merits. And so we told the archivist, don't publish until we have a decision. But we've now learned in hindsight that the courts are not actually addressing it and that they are taking the lack of publication to be determinative. And so in an abundance of caution, we think it's a good idea to rescind that OLC memorandum and replace it with this one, which simply says, we don't know. The courts should decide whether the ERA is actually validly ratified. So this was my cover letter of the memorandum. It says, and I said the memorandum makes these following, and so it's a replacement memorandum. So I was hoping somebody could get it over to the Department of Justice, and some really good person at the Department of Justice would say, oh, this is brilliant. Of course, this is right. Let's rescind that terrible 2020 memorandum and replace it with this brilliant 2024 memorandum. So what the memorandum says, this quote unquote replacement one, is that the OLC overstepped its authority by even opining, because the executive branch has no authority, right? The president has no authority in constitutional amendments. OLC overstepped its authority when it issued its January 2020 opinion and concluded that the deadline was valid. Should not have done that. Should have been left to the courts. The instruction to the archivist not to publish has led to a stalemate in the courts that need to be removed. Whether the ERA is validly ratified and thus constitutes the 28th Amendment is a matter of immediate and compelling public interest that ultimately requires judicial resolution. Sounds good. Publication, although a purely ministerial act, has become necessary to enable the courts to move forward and address the merits of the deadline and rescission issues. And then finally, the legal arguments on both sides of the ERA's validity are sufficiently strong to justify repeal and replacement of the 2020 OLC opinion. So I got this, plus the memorandum and my little cover letter, to a couple of people who are going to Vice President Harris's Christmas party. And I'm like, get it to somebody, get it to Vice President Harris. And then that person took it, and then she's like, well, I need one with a letter to President Biden too. We're going to get it into President Biden's hands. So, we did that, and nothing happened, dead silence. And then on January 17th, President Biden announced that he has supported the ERA for more than 50 years. And I have long been clear that no one should be discriminated against. It's long past time to recognize the will of the American people. In keeping with my oath and duty to Constitution and country, I affirm what I believe and what 3/4 of the states have ratified, that the 28th Amendment is the law of the land, guaranteeing all Americans equal rights and protection under the law, regardless of their sex. So I think the important point about this is what I really wanted him to do was do what Trump would have done, which was to order his Office of Legal Counsel to issue my new memorandum. But he, having a conscience and following the law, says it's not appropriate for the president to influence the Department of Justice. So I'm just going to stay here and I'm just going to say, I think this ERA is valid. And I'm not going to influence the Office of Legal Counsel. But then, of course, 3 days later, Trump takes over and we now have Pam Bondi as the Attorney General. So I don't anticipate my brilliant memorandum ever replacing that terrible 2020 memorandum. But that was really the only thing we could think of as sort of the best strategy for how we could get past this stalemate on the ERA, because these are very valid legal questions, the deadline and the rescissions, but we haven't gone anywhere. So where are we now? As of January 27th, 2022, the ERA is arguably valid. It's met the technical requirements. No court has addressed the question of the congressional deadline or the rescissions on the merits. And any litigation is probably going to require a private citizen suit with appropriate standing. That's the other thing. We had to wait 2 years to bring a private citizen suit because of that 2-year delay. So you couldn't just bring a suit right away saying my rights have been violated or someone else's rights, because it took 2 years before the amendment was supposedly going to go into effect. So that's where we are. I hope everybody, thank you. Did I No, okay, I'm sorry, I took too long, but it was the clicker. You want one for questions?
Okay, I have a question. If a president wants to get rid of an amendment, how does that work? Like maybe the 14th Amendment?
Well, technically, the president wanted rid of the 18th Amendment and it took another amendment. So at least at that time, when we wanted to repeal the Prohibition Amendment, it took another amendment. And the Supreme Court did say, like, there were numerous lawsuits against the Prohibition Amendment, attempting to sort of, you know, the deadline being one, but some other things, other quirks, I guess, challenges to it. And the courts said it met the technical requirements. We are not challenging. We are not striking down this amendment. It met 2/3 of Congress, 3/4 of the states ratified. We are not going to accept any challenges. And that's why it required a constitutional amendment to repeal it. So I would like to think that repeal of the 14th Amendment or the 19th Amendment, which I've heard a lot of talk about repealing women's suffrage amendment, would take another constitutional amendment. But then, you know, we're trying to repeal birthright citizenship, which is part of the 14th Amendment as well. So I don't know.
Questions? No questions.
It's really frustrating, as you can imagine, right? Like to look at the situation and say, I really do think this is a validly enacted, like it meets the technical requirements. The only question is, does Congress have authority to impose that deadline? I don't see it in the Constitution. Sorry.
Very interesting indeed. And that is, what arguments today could folks make about why we don't need an equal rights amendment? I mean, I think time has passed since it was first introduced and culture has changed, et cetera. What arguments are being brought against the equal rights amendment?
Yeah, so when it failed to pass the deadline, and then when the deadline was extended into 1982 and it failed to be ratified, a sort of legend, if you've all seen On the Basis of Sex, the movie about Ruth Bader Ginsburg, but she went in and she had a strategy to bring lawsuits to the Supreme Court where men had been discriminated against on the argument that sex discrimination was unconstitutional. And so by bringing these lawsuits, and this is why I think men having to register for the draft is the quintessential case. You bring this sort of reverse discrimination case. RBG got it up to the Supreme Court and got a number of decisions. It took a while, that said that discrimination on the basis of sex it's not as bad as discrimination on the basis of race. It doesn't get what's called strict scrutiny. It only gets intermediate level scrutiny, but it's better than no scrutiny at all, which is basically what most classifications get. So we do have law coming out of the Supreme Court that has said the 14th Amendment's Equal Protection Clause protects on the basis of sex, but it's a less stringent standard. So we can have sex-based distinctions in our law that you really can't have any race-based distinctions at all. So two things that if we had the ERA, I think would happen. One is that level of scrutiny would move up to strict level, which means the state would almost always fail if it has a specific sex-based distinction in law. The other is abortion. The argument is that once you move that to strict level scrutiny, then reproductive rights are going to probably have to be protected. I mean, I think the Supreme Court, as it's currently constructed, might not feel that way, but at some point, that's the general argument. So the ERA would get Roe versus Wade back again. But both of those, as we know from Roe, that can be changed. The Supreme Court can change its mind. The constitutional amendment, it's going to take a constitutional amendment to change it. And so that's why people want it in the Constitution.
I just want to say I was extremely surprised to see the title of the meeting tonight, because I haven't heard anything about this for like 30 years.
Right.
And I'm wondering.
That's how I felt.
And I'm wondering, why now?
Well, I think Why Now makes sense. It was part of the Me Too movement. 2017, 2018, the states just started saying, look, we got to get this back. And there was a concerted political effort and money put in to the 3 states that they thought were the most likely states. So I got involved in this after Illinois ratified around 2019, before the Virginia ratification. And we were sitting around talking about which state do we think is going to be the one that's going to put it over the line. But there was a lot of money spent. It was called the 3-state strategy. Let's get these last 3 states and then we can get it into court. But we can't seem to get it into court. So, yeah. But it's a lot of people haven't heard about it. And if you look at the technical requirements of the amendment, it's the 28th Amendment. It has met the technical requirements. But we can't get, and so, it's going to take a lot of money and a lot of litigation in the right court, of which I think there might be a judge in Tallahassee who could potentially be a really good judge. That we need to get a judge who's actually willing to address it instead of just say, oh, well, it hasn't been published, so doesn't exist.
Other questions?
But I think, just talking about it and raising people's awareness is important. But the legal issues are absolutely fascinating. There's no guidance. We have no case law on this. I can count on my fingers and toes the number of US Supreme Court cases, and my fingers and toes the number of cases in all the federal courts dealing with Article 5, the process of Article 5. And that's not many after 240 years.
I'm wondering if a case where a husband lost his wife because she couldn't get adequate abortion care would do it. If that could be
Yeah,
the RBG case that gets it up there.
yeah, yeah.
If the husband lost his wife,
Right.
not did we lose the wife,
Right, of
But
course.
did the
because we don't
husband
care
lose
about
his
that.
wife?
Did the husband lose his wife? Yeah, yeah. So that would be interesting. We have generally speaking stepped away from the law's position that the wife is a chattel of her husband and the property of her husband. But there's a lot of case law out there that says loss of consortium, loss of her services. That's always really interesting. Loss of her services is it's a violation of his rights. I don't know that would work, because there's a lot of people who would say his rights in his wife should not be recognized in that way. So I don't know. It's a good question. Maybe, well, it should be recognized. Oh, are you kidding? But just the idea that it's a wrongful death suit, right? Because she died. I think that she was not, because what you're looking at when we're talking about equal rights, so whether it's the 14th Amendment or the Equal Rights Amendment, it's when the law classifies people into 2 different categories. Is that classification a justifiable classification? And if you think about a lot of classifications, like people who are blind can't get driver's licenses, you're like, okay, that makes sense. But there's a lot of classifications that might not make sense. So if we really think about it, and then there's also, it's a benign classification, right? Not all women are going to need an abortion. So that's the other thing. The Supreme Court had this great opinion, great in quote marks, where it was on the Pregnancy Discrimination Act. And they said, well, only women are in the category of pregnant persons, but men and women are in the category of non-pregnant persons. And so it's not discrimination against women because there's women in the category of non-pregnant persons. And so, I could see some kind of argument that would build on that type of argument if we got to the reproductive rights. But you can say it's not a classification against women as a sex, but it does have disparate impact on them. It clearly has it doesn't have maybe it has a disparate impact on men as well, but it doesn't have this disproportionate, it's the disproportionate impact that makes the classification unjustifiable between those who can get an abortion and those who can't. And since it's always going to fall on women, that's a potential problem. But the current court, as it's currently constructed, I can't see it even going there. John,
Oh,
hold on. You got to,
another question?
yeah.
How does the law define the word sex? Does it apply to LGBTQ, transgender, transvestite, et cetera? Will they also
Yeah,
Mm.
yeah.
be spared discrimination?
So this is a big issue that has since the 90s has been a really major concern. So as I said earlier, the court has interpreted the Equal Protection Clause of the 14th Amendment to prohibit discrimination on the basis of sex. In all of the gay rights cases, so Windsor and Obergefell, the same-sex marriage cases, they have refused to say sexual orientation is a suspect classification. So sexual orientation gets what's called rational basis scrutiny. So if the law says gay people can have a driver's license or cannot have a driver's license, but straight people can, that's fine, right? Because the distinction between gay and straight is not a suspect classification. Rational basis, if they could come up with a rational basis, that would, so because we have these three levels of scrutiny, and race is at the top, sex is in the middle, sexual orientation is at the bottom. So that's where we are constitutionally. But the Supreme Court interpreted Title VII of the Civil Rights Act to say discrimination on the basis of sexual orientation is sex discrimination under the statute. But they have never said it's sex discrimination under the Constitution. And so they could just, Congress could change the statute, they could amend it. There's a lot of things that Congress could do. So right now, sex means sexual orientation, gender identity, gender expression under statute, but not under the Constitution.
This is getting more complicated by the minute.
It is. It's very, right now they're talking after the Dobbs case reversed Roe versus Wade, and Justice Thomas said, I don't think that same-sex marriage case is good anymore, right? He wants to roll back all of and if you think about the rights that come under that privacy umbrella that we use to validate the reproductive right in Roe, is the right to same-sex intimacy, the right to same-sex marriage, the right to refuse medical treatment, the right to contraception, the right to basically marry who you want. Like there's a lot of private laws affecting your private life and private decision-making that have all been struck down under that due process privacy argument. Now, the court just said in Dobbs, that's an illegitimate basis for reproductive rights. So everybody's terrified that the right to contraception, that these other rights are going to fall as well. Right to privacy generally, right? The right to informational privacy, to have the government not surveilling you. That's all part of that right to privacy that was used to validate abortion rights. I'm going to give everybody a nightmare over here. Oh. Are there other? Oh.
Well, we have two more questions, then we better call it quits.
Yeah, then yeah.
Are there other liberal democracies in the world that have successfully tackled this question? And in some, to their own, the ones you've raised, and to their satisfaction, resolve the issue?
So Other liberal democracies, probably yes. I'm not that familiar with a lot of them, but what's interesting is a lot of states have equal rights amendments. And in some states, New Mexico being one, they have said that elevates sex to this higher level of scrutiny, greater protections. And in fact, they interpreted that equal protection clause to protect abortion rights. Florida, in its 1990 something, 95 constitutional revision, added a privacy amendment to the Florida Constitution. And that was to sort of mimic this constitutional provision that had been recognized in Roe and Griswold and various cases that under the US Constitution, that people have this realm of privacy, of intimate, right to privacy for intimate decision-making. And all 7 justices in a 2000 case said that right to privacy in the Florida Constitution applies to reproductive rights and abortion. Just got overturned by the Florida Supreme Court, which said, no, that's not what we meant by, that's not what the people meant by privacy when they ratified that constitutional amendment after the privacy, right? I mean, after we had already created Griswold and Roe and we had done all of these recognized privacy as this important zone of constitutional protection, the Florida Supreme Court in a 6-1 decision, I believe, said, no, that's not what the Florida people meant. They just were talking about privacy in documents. They weren't talking about privacy in their own lives or decision-making. So yeah, you can keep your address private on the public website. Yeah, that's what they were thinking when they passed that. That's how they got the 6-week abortion ban to be validated. So what the states have been doing now, some states have strongly protected a lot of these things, either through privacy or through equal rights. We don't have, actually, now that I say that, I think we do have an equal rights amendment. No, we don't. We don't have an equal rights amendment in Florida. But if we did, we interpret it at the same level as our sort of lower level, the way that the Supreme Court has interpreted equal protection. And then privacy, we've said, well, we didn't really mean that. So that's where Florida is. But there are some states, there's some other countries that have certainly done better than we have. And Ireland now has reproductive rights, which they resisted for a long time.
Any more questions?
I can talk about this forever.
You've given us so much to think about.
Past
Thank
my
you.
bedtime.
Thank you so much for coming.
Thanks. Thanks for having me.